Good morning, Your Honour. For the record, my name is Rolls, initial JP. I appear before you on behalf of the applicant, Mr. Marshall Ike. I shall be presenting submissions pertaining to Mr. Ike's application under Section 590AA, subsection 2 of the Code regarding the admissibility of evidence. To begin my submissions, I'll give a short summary of the salient facts of this matter. My client is a 14-year-old male of Torres Strait Islander descent. He has been charged with a total of 85 property-related offences. Your Honour, I again emphasise my client is a juvenile and clearly identifiable as an Indigenous Australian. As such, the arresting officers were bound to adhere to certain procedures found in the Police Powers and Responsibilities Act, the PPRA, and the Police Powers and Responsibilities Regulations, the PPRR, pertaining to the questioning of Mr. Ike. My client was apprehended a short distance from the locus in quo by two police officers. Upon detaining Mr. Ike, the officers proceeded to search the backpack in his possession, in which several electronic items were found. At this point, he was placed under arrest. Your Honour, at no point in time did the arresting officers attempt to ascertain the applicant's level of understanding regarding the circumstances of his arrest or even his age. After being placed under arrest, Mr. Ike was put in the back of a police vehicle, where the interrogation by the two officers continued. I've been informed that my client was driven around the neighbourhood where various houses were pointed out to him, and he was asked whether he had broken into them as well. My client has indicated that he answered in the affirmative to each question posed. He was then taken back to the police station for further questioning. Upon entering the interview room, he was introduced to a social worker who was previously unknown to him. He was told by the officers that Mary was to be his support person, after which she told my client to simply answer the officers' questions. Your Honour, I submit that the actions of the two officers in dealing with my clients have breached several statutory requirements contained within the PPRA and PPRR. As such, I am seeking to exclude evidence obtained against my client at the scene of the alleged incident, during the drive around the neighbourhood, and also during the recorded interview. If it pleases the court, I wish to bring Section 421 of the PPRA to Your Honour's attention. This section applies where an officer wishes to question a relevant person, and the officer reasonably suspects that person is a child. The police record shows that one of the officers referred to my client as young fella, indicating they possessed a reasonable suspicion he was a child. Therefore, this section ought to have applied from the very moment the officers apprehended my client. Subsection 2 states that an officer must not question the child unless, if practical to do so, has allowed the child to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard. Accordingly, my client should have been allowed to speak to a support person at the scene of the alleged incident and also during the drive around the neighbourhood, yet no such opportunity was provided. Furthermore, I wish to emphasise the importance of the phrase chosen by the child contained in subsection 2. While a support person may have been provided in the interview room prior to the interview, this person was unknown to my client and chosen and summoned without his consent. Such actions are in clear contravention of the PPRA. Your Honour, I further submit the officers were again in breach of their obligations regarding the questioning of my client. Section 418, subsection 1 of the PPRA and Schedule 9, section 23 of the PPRR provide the right to communicate with a relative, friend or legal representative prior to the commencement of questioning. Yet the arresting officers failed to inform my client of this right. Such a failure is in clear violation of the PPRA and PPRR. Your Honour, the actions of the two officers have placed Mr. Ike in a distressing and prejudicial position where he has been given no support by a chosen relative, friend or legal representative. The so-called support person he has been provided has further damaged the interests of my client by telling him to answer the officer's questions without identifying the clear distress he was experiencing. Despite not complying with Section 421, subsection 2 of the PPRA, the officers should at least fulfil their obligations under Section 34 of the PPRR. In accordance with Section 34, subsection 2C of the regulations, the support person should have been provided with a statement that outlined she should have asked my client questions to ensure he understood his right to silence during questioning. If this statement had been provided, the social worker's contribution to the interview process may have been far more positive. This breach of the PPRR is the final point I wish to submit on behalf of Mr. Ike. The submissions made on behalf of Mr. Ike indicate the evidence was against him was obtained illegally and therefore invalid. I seek orders from Your Honour to have both the police record and recorded interview excluded from evidence. The basis of the application for such orders are founded upon the concepts of fairness identified in Section 130 of the Queensland Evidence Act, and also the Court's inherent discretion to exclude evidence for public policy and fairness reasons. In relation to the Court's exclusionary fairness discretion formulated and developed in the case of the Crown and Hasler and the Crown and Christie, I submit that any admissions made by Mr. Ike are of little probative value. The police and interview records illustrate my client was displaying gratuitous concurrence, which is the tendency to assent to every proposition put to him, even when he does not agree. My client answered in the affirmative to the officer's questions, not for the purpose of admitting to offences, but rather to curry favour with the officers. Given the significant prejudice the admission of such evidence would have against my client, compared to its little probative value, I submit it is well within Your Honour's discretion to exclude the evidence under the fairness discretion. The Court also has the discretion to exclude evidence for public policy reasons, under the principles found in the case of Bunning and Cross and the Crown and Island. I submit that the officers who apprehended my clients deliberately breached their statutory obligations on numerous occasions when questioning my client. Given their violations were substantial and repeated, there should be no excuse. Finally, the officers' breaches are in clear violation of Section 5E of the PPRA, which dictates police must ensure fairness to and protect the rights of persons against whom police officers exercise power under this Act. My submissions before the Court have demonstrated that the officers failed to adhere to this requirement when questioning my client. Therefore, I submit it is well within Your Honour's discretion to exclude all oral evidence provided by my client for public policy reasons. That concludes my submissions before the Court.